Form DV-100 is the form that you fill out as a form number 1. So DV-100, you are typing in, you can fill it out and you can download the form online. Name of the person asking for protection. That would be you, your age. If you have a lawyer, fill it out. Obviously, if you have a lawyer, you wouldn't fill it out. So the lawyer would be filling it out for you. So you leave this section blank. And then if you don't have a lawyer, then keep your home address private, give a different mailing address instead. And if you have, make sure to not put your telephone, fax, or email address here as well, because the whole purpose is to protect you from perpetrators and not to make this information easily available. So number 2, who do you want to be protected from? And then you type the name in number 2, the perpetrator's name. You see, Phil, on the right side, you can see Superior Court of California, and then county. It would be your county where you are residing or where the abuse is happening. Could be San Francisco, could be San Mateo. So you got to look up the address of the court. Don't just copy this address. Case number, you don't have it because it's when you initiate the filing, the case number is going to be given at the time when you file it. Then description of the person you want protection from. Make sure you fill everything out as much as you can, because otherwise it may get bounced if the court doesn't know this information. In number 3, if someone is living with you who you would like to be protected, such as child or someone, a partner, neighbor, anyone who is living with you, you fill out this information and type in relationship to you. So what is your relationship to the person number 2? And that is the perpetrator. And here's, so to say, the definition of the domestic partner. It could be married or registered domestic partner. It used to be ex-husband or ex-partner, or someone you're living together with or used to live together, we're already by blood, marriage, or adoption related, or used to date or engaged, or it could be parent-child relationship. So that is how you know whether this restraining order is applicable to you. It's going to make a difference whether it's a civil restraining order or domestic violence restraining order you're seeking. In number 5, other restraining order in court cases. So for example, if you had a case on about divorce, then you fill out when that happened, case number, divorce nullity, and then you type in all the information it's required in 5B, if there was a child support case, parentage case. So that way the court can look up the history, the information. Perhaps there is important information that the court can include and before making a decision. In number 6, you asking what type of personal conduct orders you would like the court to make. And usually that's what the court will check on the order form, DV-110. So you're asking to, so not to harass, attack, strike, threaten, assault, sexually or otherwise hit, follow, stalk, molest, destroy personal property, disturb the peace, keep under surveillance, impersonate on the internet, electronically, or otherwise, or block movements. And then in B, contact either directly or indirectly. So indirectly would be if the perpetrator is contacting you through a friend who calls you and tries to harass you in any way, including but not limited to by telephone, email, mail, or other electronic means. The person in number 2, that's the perpetrator, will be ordered not to take any action to get the address or location of any protected person unless the court finds good cause not to make the order. So you check off A, B, and remember at the top. In number 7, you're asking to stay away. And then typically we put 100 yards, and then me, my home, my job, my vehicle. If you're in school, my school, each person listed in 3, which is the person you listed who lives with you, the children, school, childcare. And then if it's not listed, I don't know, maybe you're living in a trailer. So you check off other and check that one and type what location that is. And then B, and remember, location, you don't have to put an address, you can put trailer. So that's good enough. In B, if the person listed in number 2 is ordered to stay away from all places listed above, will he or she still be able to get his or her home, job, work address? And then if you say no, explain. For example, if you live together, then ordering 100 yards to stay away would technically make this number 8 move out order. So, but if you don't live together, that's different. If you work together, so that's going to be also important to find out. I had a case where we had to say at least remember 6 yards. No, it was 6 feet, because the couple was living together and worked together. We couldn't separate them in a way that wouldn't destroy the business and make one person homeless. So that's how we resolved this. It wasn't very effective because they still were so close to each other, but that was a temporary solution. Eventually, one person had to move out. So in number 8, if the person in number 2 lives with you, so the perpetrator, and you want that person to stay away from your home, you must ask this move out order. Ask the court in order to order the person to move out from and not return to. And then here is where you state the address. It's not confidential because obviously that person lives with you, so there's no point to hide this address. I have the right to live in the above address because you're married, you are on the lease, it's your roommate, whatever the reasons are. If you are aware in number 9 of guns or any firearms, then you state it here. Number 10, record unlawful communication. As you know, without other person's consent, you're not allowed to record unless you expect in this recording to be domestic abuse. So that takes the burden of you to sort of predict that and not violate the penal code section and record any communication that the other person will do, because it will be unlawful, right? Because the court will order, for example, do not contact me, and that if the person contacts me and talks to me, I can record it because it automatically becomes unlawful, even if it doesn't per se is abuse or this person doesn't use abusive language. If you have care of animals, you can state it right here. Number 12, child custody and visitation. If you need child custody and visitation, then you need to check it off here. If you ask for this, you must fill out and attach DV 105. That's a different form, a request for child custody and visitation orders separately in that form. And you and the other parent may tell the court that you want to be legal parents of the children. That's a different form, agreement and parentage. Use the DV 180. So you will be attaching the additional forms required, DV 105 to the DV 100. And I wouldn't staple them together, so I wouldn't really attach. It would be just chronologically stapled DV 100 and attached declaration, and then DV 105, DV 110. So I would chronologically staple them together when bringing to court with 2 copies. If you have a child involved, I would check off child support because it can go retroactively to the date when you file a restraining order. And then remember, you need to fill out form FL 150. That's an income and expense declaration. And I have a video how to fill this form out. In number 14, property control. Ask the court to give only me temporary use, possession, control of the property listed here. Some people list businesses. I had a case where on a temporary basis, the wife had absolute sole control of the business temporarily. Debt payment here could be mortgage payment. So if the move out order is still granted, but the victim doesn't have money to pay for mortgage, then the perpetrator would be required to pay mortgages and telephone bills and utilities. And if there is not enough space, you can just say attached to number DV 100, number 15, and attach a spreadsheet of everything that needs to be paid. Number 16, property restrained. I'm married or have a registered domestic partnership with that person. And number 2, the perpetrator asks the judge to order that the person number 2 not borrow against, sell, hide, get rid of, or destroy any possession or any property except the usual course of business or for the necessity of life. I also asked the judge to order the person number 2 notify me or any new or big expenses and explain to them to the court. So this is an automatic restraining order that typically is already triggered with the divorce. It's on the form FL 110 on page 2, where even separate property cannot be spent unless it's for necessity of life or paying for attorney's fees. It doesn't say here for attorney's fees, but it would be considered usual course of business. So that is a repetition of that in case divorce has not been filed. You can check off spousal support, and remember, if you're asking for spousal support, to attach FL 150. So number 18, right to mobile device and wireless phone account if you are still requesting temporary use of possession and control of the following mobile devices. So you list them here. Debt to wireless phone accounts, also in B, or C, transfer wireless phone account. Insurance in number 19, attorney's fees and costs. Remember, if you check it off, attach FL 150. And then payments for cost and services as the court in person 2 to pay for the following. And I usually don't check off as many things, usually child support, spousal support, attorney's fees, and temporary orders, but not too much, because remember, the court will have, the first hearing will be 20 minutes. It's going to be, even if it's granted on a temporary basis, it's better to focus on the most important thing, which is the abuse, and everything else reserved for a regular calendar, because domestic calendar is expedited. So I choose wisely what I check off. Number 22, batterer intervention program is 52 weeks batterer intervention program, show proof of completion of court. This is important if someone is, obviously, if you're filing for domestic violence, the other side is probably violent and in some shape or form. Therefore, 52-week batterer intervention program can help. I don't know if it's really helpful. I think therapy, 52 weeks weekly would be more helpful, but that's just my personal opinion. That's how this form is structured. In number 23, anything that wasn't mentioned above, then you will add it here. Time for service. So time for service meaning you're asking the court, you're asking the court how quickly do you need to serve the paperwork, that the temporary restraining order, to the other side. And the paper must be personally served another person, number 2, the perpetrator, at least 5 days. It doesn't say business days. 5 days could be the weekend plus 3 days before the hearing, unless the court orders a shorter time for service. If you want there to be fewer than 5 days between service and the hearing, explain why below. For help, read DV 200-info, what is a proof of personal service. So again, that could be sheriff, that could be private, could be private personal server or process server. Number 25, no fee to serve. Notify restrained person. If you want the sheriff or marshal to serve, notify the restrained person about the orders for free and ask the court clerk what you need to do. So ideally, you just go to the police department and ask and produce the paperwork that you got from the court back after 24 or 48 hours since you submitted it, and then they will let you know what they need. I don't think it's free. I think it costs money. 26, court hearing. The court will schedule a hearing on your request. If the judge does not make the order effective right away, temporary restraining order, the judge may still make the order after the hearing. If the judge does not make the orders effective right away, you can ask the court to cancel the hearing. Read DV-112, waiver of hearing or denied request for temporary restraining order for more information. Okay, so now in 27, this is going to be the most important piece where you get to tell your story. And the way it is structured, you need to describe how the perpetrator abused you. Abuse means to intentionally or recklessly cause an attempt to cause bodily injury to you, or to place you or another person in reasonable fear of imminent serious bodily injury, or to harass, attack, strike, threaten, assault, sexually otherwise. Remember, it's the same language that we had above. Hit, follow, stalk, molest, keep you under surveillance, impersonate on the internet, or otherwise batter telephone or contact you, or to disturb your peace. Since 2016, disturb your peace is a new language, so it doesn't have to be physical, or destroy your personal property. For a complete definition, see Family Code 6203, 6320. And now, date of most recent abuse. So this is what I usually do. I type the date of the most recent abuse, who was there, so in case you have witnesses, and then to describe the person, describe how the person number 2 abused you with the children. And this is where I say, please see petitioners, it could be respondents if you have already divorce case, declaration attached, here too, and then I actually attach a declaration. It could be a Word document. It says attachment to DV 100, number 27, and then usually you look at number 3. How did they threaten you? Describe any injuries. Did the police come? So read these descriptions, and if any of those apply, then include that in your description of abuse. In number 27, same here, describe who was there, witnesses, injuries, police, who was, if you have police report, attach police, anything that can help your case, attach it. It doesn't hurt. If you have a declaration, you have attachment, do not attach it into the Word document, make it an exhibit, say, see exhibit A, and attach exhibit A and mark it on the bottom so the court, when the court flips the pages, can see the exhibits. And then in 28, the person listed in item 3 need an order for protection because. So if, for example, you have a neighbor or a child, describe how they got affected and why they need protection. And then in number 29, because as I suggested, we need an attachment. So then you count the pages of attachment, all of them, including exhibits, and say how many. And then remember that you're justifying under penalty of perjury and under the laws of state of California that the information above is true and correct. Date it, type and print your name, sign it, and then remember, if you don't have a lawyer, then you skip that part. And that is DV 100. If you have a child as a protective person, and number 3 on the form DV 100, then you need to fill out DV 105, as we talked before. So then you type your name, your relationship to this child, you say your mom, and other parent's name and relationship to the child. And if it's other, then you type in what it is. I asked the court for custody as follows. Check off number 3, child's name, date of birth, mom, legal physical custody. And here's the definition of legal custody: person who makes decision about health, education, and welfare, and physical person who wants to live with the child. Number 4, if there is a prior order, then number 4, you say change current court order and case number, county, and explain how you would like to change the current order. For example, if the current order says joint legal custody, then you're saying you're asking to change it to a different order. And then attach same type of declaration. You will just say attachment to DV 105. Number 5, child's address. Child's address we talked about, other children addresses. Number 7, other custody case, describe that. Number 8, other people with or claiming to have custody, need to fill it out if there is such a thing. Here in number 9, there is a checkbox missing. It disappeared. And then in C, the following visitation orders, you can say no visitation until the hearing, which is going to be temporarily, no visitation after hearing, or he can propose a visitation. For example, no overnight or just weekdays. Fill it out based on what you need. Responsibility, other visitation, attach sheet on paper and visitation day and times like summer vacation, holiday. I wouldn't do it because remember, it's just a temporary order. You will get a hearing within 24 days from filing, so there is no need to, I never fill out number 10. Number 11, the parent will take or pick up the child and make arrangements for someone else to do so. I asked the court to order that mom take the children to the visits, or you just fill out how you feel comfortable to do the visitation. Number 12, supervised. You can ask for professionally supervised. So professional supervisor is going to write reports and is professional, meaning the person knows how the system works and will have to do intake. The perpetrator have to pay hourly for the professional supervisor. Or if you find that non-professional supervisor is there, you can specify. For example, if you know the perpetrator's parents are well and you trust them, then you can say, well, his parents can supervise. That can happen too. And then remember to say in number C, I asked at the court that the cost of the supervision be paid by dad or other, whoever the perpetrator is, 100%. Same as remember to check off number 13, the box. And then I asked the court order that dad must have written permission from the other parent to make take the children outside of the state of California, county, or even not take them anywhere. If you have abduction risk, you need to check off number 14. So that's it to the form DV-100 if children are involved, DV-105. Next would be notice of a hearing, DV-109. This is the form that you do need to fill out. And this is very similar to DV-100, DV-110, so I'm going to skip that. You don't fill out number 3 because the court will. And temporary restraining orders, any orders granted are attached. And so you don't fill out because you don't know what the court is going to order. And then I also do not fill out any of this because the court will fill out the rest. And the clerk service in the court will sign this.
Next form, DV-110. All you need to do is to fill out number 1, 2, and 3 the same way you did in the form DV-100. The rest is for the court to fill out. The clerk will fill out number 4 to set a hearing date, and all other numbers will be checked off by the judge.
A lot of people forget this form, CLETS-001. CLETS is California Law Enforcement Telecommunications System Information Form. This is submitted with the initial filing date, and you submitted when you submitted with the case number. So this form must not become part of the public court file. It is confidential and private. Fill out as much information as you can and give it to the clerk. If the court issues a restraining order, this form will provide law enforcement with information that will help them enforce it. If any of this information changes, fill out a new amended form. So then if you know the case number, obviously if you're initiating the filing, you don't. And then same thing that you did on DV-100, DV-110, person to be protected, person to be restrained. You see there's social security number, so you don't have to worry about it because the clerk is not going to file this form. And number 3, gun or firearms, other people to be protected. So remember to file this form. Sometimes it gets bounced because you don't file this form. That is it for today's video. And I hope that was helpful. I will talk to you soon. If you have any questions, call me. And if you like the video, click like, subscribe, and have a good day. Bye.